The judge has dismissed altogether the $400 million defamation lawsuit filed by director Justin Baldoni against Hollywood power couple Blake Lively and Ryan Reynolds. The backstory: Lively had initially filed a civil lawsuit against Baldoni, claiming that while working on the film It Ends With Us.
Today, we're really jumping into a pretty significant legal development. It involves some, well, very recognizable names in Hollywood and a major media outlet, too.
That's right. And we've got some fresh information basically detailing a big court ruling that just landed.
Yeah, exactly. So what we're looking at is the recent dismissal of these, well, substantial lawsuits.
Yeah.
Filed by Justin Baldoni and the Wayfarer parties.
Right, and they were targeting Blake Lively, Ryan Reynolds, their publicist Leslie Sloan, and also separately, the New York Times. Big names all around. Absolutely.
And our mission today really is to sift through all this for you, pull out the really essential pieces.
Yeah, the core nuggets.
We want to make sure you get a clear picture exactly what claims were dismissed, who was suing who, for how much, and the sums are quite large here.
Oh, yeah.
And crucially, the judge's reasoning for tossing these cases out, plus, the immediate reactions from the folks involved.
It's about getting to the heart of this legal twist, basically, without you having to wade through all the legal jargon yourself. We're boiling it down.
Exactly. Understanding the outcome and why, at least according to the judge, these specific claims didn't make the cut, all based directly on the info we have.
Okay, so let's get into it. What happened on June 9th, 2025?
Right. So on that date, Judge Louis J. Lyman in New York, he issued a ruling, and it granted motions to dismiss these lawsuits brought by Baldoni and Wayfarer.
And this wasn't small change. It included that huge $400 million suit against Lively, Reynolds, and Sloan.
$400 million, yeah. And then there was another one, right?
Yes, a separate $250 million lawsuit just against the New York Times.
Wow. Okay, so you add that up. That's $650 million in lawsuits just dismissed. What was the judge's core reasoning? Why did these claims fall short according to the ruling?
Well, the judge broke it down. There were kind of distinct reasons for the different claims. So first, let's look at the claims aimed at Blake Lively. The ruling said that the Wayfarer parties hadn't actually alleged Lively was responsible for any statements outside of those in her original CRD complaint.
Ah, the CRD complaint, that's the one Lively filed as sexual harassment and retaliation against Baldoni, correct?
Exactly. And the key point here, which the judge really underlined, is that statements made within a formal legal complaint like that, well, they're usually considered privileged.
Okay, privilege.
Yeah.
So in this context, that means they have a sort of legal shield. You generally can't turn around and sue someone for defamation based only on what they put in their official court filing.
Precisely. It's a protection, designed to let people bring grievances to the legal system without immediately facing a countersuit just for filing the complaint itself.
Makes sense.
And because Wayfarer's claims against Lively seemed to be rooted in those complaint statements, they were deemed privileged. So they couldn't form the basis for this defamation suit against her. That part got tossed.
Got it. Okay, that covers Lively. But what about the claims against Ryan Reynolds, Leslie Sloan, and the New York Times? The info we have says Wayfarer alleged they made other statements.
Right, they did. Wayfarer did allege that Reynolds and Sloan made additional statements, accusing Baldoni of sexual misconduct.
Okay.
And they also alleged that the Times, in its reporting, accused the Wayfarer parties of running a smear campaign.
Right, I remember seeing that.
But the judge found that the defamation claims based on those alleged statements failed too, but for a different, really specific legal reason.
And this reason sounds pretty fundamental, doesn't it?
Oh, it is. Very much so in defamation law. The judge stated these claims failed because the plaintiffs, Baldoni and Wayfarer, they did not actually allege that the defendants, Reynolds, Sloan, and the Times, would have seriously doubted the truth of those statements.
Seriously doubted the truth.
Ugh.
Based on what they knew when they said it.
Exactly. Based on the information available to them at the time. This serious doubt standard, it's a very high bar to clear in defamation cases, especially when you're dealing with public figures or matters of public concern like this clearly is.
Huh. So it's not enough just to say the statement was false.
Right.
You also had to allege, essentially, that the person saying it either knew it was likely false or just recklessly didn't care if it was true or not. Is that about right?
That's a great way to put it. Reckless disregard for the truth or actual knowledge of falsity. And because Wayfarer's lawsuit apparently didn't include that specific allegation that Reynolds, Sloan, or the Times had these serious doubts, the judge said, well, the defamation claims against them can't stand either.
Wow.
So he ruled that Wayfarer's entire amended complaint, including some other additional claims the source mentions, was being dismissed. the whole thing.
That feels pretty definitive based on those legal points.
Yeah.
And as you'd imagine, the reactions from the other side, the defendants, they were quite strong based on what we're seeing.
Oh, absolutely. Lively's lawyers, Ezra Hudson and Mike Gottlieb, they put out a really forceful statement. They called the decision a total victory and a complete vindication.
Not just for Lively, but for the others too.
Yeah, for Reynolds, Sloan, and the New York Times as well. They didn't mince words. They called the $400 million suit against their clients a sham and said the court saw right through it.
Strong language.
And they went even further. They said they're now looking forward to seeking attorney's fees, treble damages, and punitive damages from Wayfair
For what?
for what they called abusive litigation.
Abusive litigation. Wow, okay. That suggests they really believe the suit itself was improper, not just wrong on the merits. What about Leslie Sloan's team?
Her attorney, Sigrid McCauley, echoed that sentiment. Said Sloan had maintained her innocence all along, never defamed Baldoni or Wayfarer, and was, quote, wrongfully dragged into this lawsuit. McCauley basically said the court's decision makes it clear Sloan did nothing wrong, she stands fully vindicated, and, quote, justice has been served.
So, complete exoneration in their view. And the New York Times, what was their take?
A spokesperson for the Times also put out a statement. They expressed gratitude to the court, naturally.
Right.
They called the lawsuit against them a meritless attempt to stifle honest reporting. Said the court saw it for what it was.
So, similar themes, seeing through the lawsuit.
Pretty much. They emphasized their journalists covered a story of public importance carefully and fairly, and that the ruling recognized the law protects that kind of journalism. They finished by saying the Times will continue to defend its work and its journalists when challenged.
Okay, so across the board, the defendants are framing this dismissal as a full validation. But it's worth noting, while these huge claims were dismissed, the source material we have does mention one little area where things might not be completely over, right?
Yes, that's a good point. The judge did leave a, let's say, narrow window open. He noted that Baldoni's legal team has until June 23rd
To do what?
to potentially amend and refile certain other claims that were part of the dismissed suit. Specifically, claims for breach of implied covenant and tortious interference with contract.
Okay, hold on. Breach of implied covenant, tortious interference. Can you give us the quick, non-lawyer version of what those are?
Sure. Simply put, breach of implied covenant usually refers to this implied duty of good faith and fair dealing that's read into many contracts. It basically means alleging one party acted unfairly to undermine the other party's benefit from the deal, even if they didn't technically violate a specific written rule.
Okay, sort of like acting in bad faith within the contract.
Kind of, yeah. And tortious interference with contract is alleging that someone wrongly messed with an existing contract or business relationship between two other parties, causing harm, like improperly poaching a client or disrupting a deal.
Got it. So these sound more related to business dealings and agreements, not so much about reputation like defamation.
Exactly. They operate under different legal rules, so they wouldn't necessarily be subject to that same serious doubt standard we talked about for defamation.
Right.
So while the big defamation and sort of extortion-like claims were thrown out, there's that possibility these other specific contract-related claims could come back if Baldoni's team refiles amended versions by that June 23rd deadline.
That definitely adds an important layer of nuance.
Yeah.
And I think it's really crucial here to remember the bigger picture. This ruling, while obviously a huge deal for the defendants in these specific lawsuits, it's all happening within a larger ongoing legal situation, isn't it?
Absolutely critical context. The original complaint that Blake Lively filed way back in December 2024, the one alleging sexual harassment and retaliation against Baldoni, that is still very much active. It's pending.
So this ruling we're talking about today dealt with the countersuits and separate actions that Baldoni and Wayfarer took after Lively filed her initial complaint.
Precisely. Lively's original case, the one with the core allegations of misconduct, that's still moving forward. And the information we have suggests that case is currently heading towards a trial, maybe around March 2026.
Right, March 2026.
So, yeah, this ruling is a significant turn, maybe pruning one branch of this complex legal tree, but the main trunk, the original accusations that remain standing and is proceeding.
It really just underscores how complicated and, well, multifaceted these high-profile legal fights can get, especially when you have serious accusations, massive countersuits, media attention, everything playing out so publicly.
It really does. And looking at the judge's reasoning here, Focusing on legal standards like privilege for complaint statements and that very high bar for proving defamation, it does offer some insight into the real challenges of navigating these kinds of issues through the legal system.
Okay, so let's maybe just quickly recap the absolute core takeaways from this deep dive based on the source material we've been discussing.
Sounds good. So the main event, June 9th, 2025, Judge Louis J. Lehman dismisses the big lawsuits. That's the $400 million countersuit by Baldoni Wayfarer against Lively, Reynolds, and Sloan.
And the separate $250 million suit against the New York Times, both dismissed.
Right. And the key reasons cited by the judge. For Lively, her complaint statements were deemed privileged.
Protected legal speech, essentially.
Exactly. And for Reynolds, Sloan, and the Times, the claims failed because the plaintiffs didn't allege that crucial element. That the defendants had serious doubts about the truth of the statements they allegedly made. That high standard for defamation wasn't met in the pleading.
Got it. And we also heard those very strong reactions from the defendants who won the dismissal.
Yep. Lively's lawyers calling it a total victory, a sham lawsuit, and even talking about seeking damages for abusive litigation.
Sloan's attorney saying she was wrongfully dragged in and now fully vindicated.
And the New York Times calling the suit meritless and an attempt to stifle honest reporting. Very consistent messaging there.
Definitely. But we also noted that small caveat. Baldoni's team does have until June 23rd to potentially refile those specific claims related to breach of implied covenant and tortious interference with contract.
A small window remains open there. And crucially, context is everything. This ruling happened within the larger picture of Blake Lively's original lawsuit alleging sexual harassment and retaliation, which is still pending and heading towards a potential trial in March 2026.
Right. So where does this leave us? What does it all mean?
This is where it gets really interesting to think about, I find.
Yeah.
When you see these huge, high-profile legal battles playing out, with serious accusations flying, these massive countersuits, intense media glare, it really throws a spotlight on just how incredibly challenging it is to navigate things like truth, reputation, and legal recourse when it's all happening in the public eye. Absolutely. And this particular ruling, the way it zeroes in on the specific legal standards for what actually counts as actionable defamation, the protection for statements in a formal legal complaint, that really high burden of proving serious doubt about truth, it makes you stop and think, doesn't it?
It does. It makes you consider, what is this ruling, focusing so tightly on these legal lines, tell us about where we draw the boundaries between protected speech, what legally qualifies as alleged defamation that can actually survive in court, and just the sheer cost, financial, personal, reputational earn of pursuing these kinds of fights, especially under such intense public scrutiny.
It's definitely a heavy question, and something worth keeping in mind as this whole complex situation continues to develop.